Today's conference is largely about discharge planning. And what's happening with the definition of catastrophic impairment and what may happen could have a very drastic impact on discharge planning. And that's primarily why it was added as a relevant topic. Just to make sure that everyone here understands what this is all about, because I know we have, thankfully, a lot of people here today who work in the hospitals and a lot of private people. So just by way of a quick preamble, anyone hit in any way or involved in a car accident, whether a pedestrian, a passenger, a driver, regardless of fault and regardless of whether they have insurance, is entitled to no-fault accident benefits. But the extent of those benefits changes depending on the severity of their injury. There's a very modest amount that's available unless you suffer a catastrophic impairment. And if you've suffered a catastrophic impairment, it opens up a world of possibilities. $1 million in medical benefits are available. $1 million in attendant care benefits are available. The ability to appoint a private case manager, housekeeping benefits, caregiver benefits. So the definition from a legal perspective of what a catastrophic impairment means is fundamental. And it has a drastic impact on discharge planning, because if we can have somebody labeled a catastrophically impaired person at the hospital, it opens up the window to all of the discharge needs from a financial perspective and from a management perspective. Without that immediate access, there are extensive delays. And these changes, potential changes, may very well have those kind of impacts. So, whatever happened to the anticipated changes? Last year, I spoke at the conference, and I explained that the changes were imminent. And I suggested it would be a matter of weeks, and I was wrong. And I'll be the first one to admit I was wrong, and I'm glad I was wrong. And by the way, my presentation, the PowerPoint itself, is at tab 2 of the binder, just behind my profile. And the paper I've prepared in preparation for this is at tab A, followed by some other information that is useful and is relevant, but it was in relation to the 2012 conference. So if you want to follow along in your binder, you're free to do so. So what I'm going to talk about are changes coming. What will they be? And what are the impacts? And is there anything we can do to affect what may happen in a positive way? So let's just go back to basics about what happened and how we got here with these recommendations. The insurance legislation requires a 5-year review of the system. And the last 5-year review was published in March of 2009. And in the Financial Services Commission of Ontario's report, their 5-year review, they recommend that an expert panel be put together to review the definition of a catastrophic impairment and determine how it can be changed to make sure that the most seriously injured accident victims are treated fairly. Following that, a CAT expert panel, the Catastrophic Impairment Expert Panel, was assembled, and in April of 2011, they published a report calling for an overhaul to the catastrophic impairment definition to meet that goal of making it more accessible and treating the most seriously injured accident victims fairly. Thereafter, that same panel, CAT expert panel, put together a Phase 2 report published in June of 2011, talking about the criteria, the credentials that CAT assessors should have before being able to evaluate whether or not somebody meets this legal definition of catastrophic impairment. And then lastly, the Superintendent of Fisco made recommendations to the Minister of Finance in relation to the CAT experts' opinions and their report. And he basically suggested that he likes all of those changes to a large extent, and he recommended to the Minister of Finance that they make changes to the catastrophic definition. And that report was given to the Minister of Finance back in December of 2011. It was only made available to the public in June of 2012, though. But those changes weren't adopted. And why weren't they adopted? I've suggested 2 reasons. The first is that the Ontario Premier suddenly resigned in October of 2012. And that stopped the government's ability to do anything, especially things like insurance, which were controversial and led to media response. And the second is there was very effective advocacy by a number of groups, including the Ontario Rehab Alliance, the Ontario Trial Lawyers Association, FAIR, the Victims Advocates Group, and others, against many of the changes, and that was no doubt had an impact on whether or not the changes were made. So the bigger question is, what now? Is a change coming? Well, with pressure from the NDP government to support the budget, the current government has committed to a 15% auto insurance rate reduction over a 2-year period, starting with 8% in the first year. Now, that could potentially be done in a number of ways, but the insurance company has made it clear that a prerequisite or a part of it must be a redefinition of the catastrophic impairment definition. And in other words, the CAT definition must be narrowed. And there's a quote by Mr. Palumbo from the IBC, the Insurance Bureau of Canada, recently, where he says, quote, "We're hoping that they, the government, quickly introduce a new definition of catastrophic impairment. If you want to see some rate reduction, that's the place to start to make sure that unnecessary costs related to catastrophic injuries are taken out so that money goes to people who really need it." So that's the IBC's position. They're saying if we are forced to reduce auto rates by 15%, the CAT definition will have to be narrowed, and they're putting a tremendous amount of pressure on the government to do just that. So what are these changes? Well, there's been nothing new since I last reported on the changes in 2012. In 2012, I prepared a paper, which is tab C, I believe, of the binder, which talks about the changes and attaches to it the superintendent's report to the minister, which reviews the CAT expert panel's opinions and recommendations and advises of the superintendent's recommendations to the Minister of Finance towards those changes. And at tab, I think it's D of the binder, there's a chart, 2C, there is a chart which summarizes, and I invite you to turn it up only to have a better sense of what we're talking about. But you'll see in the left column is the current definition of catastrophic impairment by the various tests in blue. And then in the right, there are two different versions. The black writing is what the expert panel had recommended, and the red shows the superintendent's amendments to those recommendations. So that's a quick cheat sheet of what the recommendations are and what as recommended by the superintendent. But essentially what it calls for is a complete overhaul to the tests relied on. It introduces a number of tests, many of which are modern versions of the current tests. It introduces the ASIA test, the American Spinal Injury Association grade scale for spinal cord injuries, the spinal cord independence measure test. It goes back to the whole person impairment test that's currently relied on, but it says that it's got to exclude the psychological injuries, although that report that made that recommendation was released before the Ontario Court of Appeals said it would be unfair to do so. So who knows what's going to happen with that recommendation. For psychological injuries, it introduces the GAF test, the Global Assessment of Functioning, and proposes a threshold of 40 or less, which is considered to be a very onerous threshold. And then, specifically dealing with brain injuries, it introduces the extended Glasgow Outcome Scale and some standards and when that test can be applied. But what it also does is it eliminates the most commonly accepted criteria for being accepted as catastrophically impaired, the GCS test. That's the test that the ambulance do right on scene. It's redone at the hospital continuously for the first while. And if you had a 9 or less, you're automatically catastrophic. The vast majority of people, especially with brain injuries, who qualify as catastrophic, qualify on the basis of the GCS test. And it is so crucial to our work, to discharge planning, because it's an immediate test that can be done right in hospital. It can be done by paper, without an assessment. It's a bright line test according to the Court of Appeal, so there's no more wiggle room. It's 9 or less as a result of a brain impairment. You're catastrophic. You get your case manager. You can access $1 million in med rehab. You can access $1 million in attendant care. You can plan to go home and renovate your home if needed. Thankfully, the initial suggestion by the expert panel for an inpatient requirement was removed from the superintendent's recommendation, so that's apparently off the table, which is a good alteration. So let's just talk about some of the impacts of any proposed changes. It would cause major delays. So going back to the GOSE introduction, the Extended Glasgow Outcome Scale introduction, instead of the GCS, the superintendent is proposing a test that varies on the severity of the level you have to meet, depending on how far along you are. So it gets reevaluated at 6 months and 9 months. Okay. That means we, in a lot of cases, have to wait 9 months before somebody is going to be potentially accepted as catastrophic. In the meantime, they go without a case manager, without having any understanding of whether they're able to access $50,000 or $1 million, which affects total planning. It affects how you're going to discharge people. Are you going to spend the money on buying equipment, or should you rent? You can't really afford to buy it unless you know you're catastrophic. So it really has a major impact on the timing of discharge planning, the coordination of all the benefits, and it puts pressure on the hospitals to extend the stay. I'm not going to want my client coming home not knowing if they're catastrophic, if there's any chance I can keep them at the hospital and get the impressive, valued service they can get there, the intensive services. So there's going to be an enormous amount of pressure on the hospitals to keep patients there longer, from the private teams that are involved, from the lawyers, from the patients, from their families. And it'll cause gaps in treatment, because while we're waiting to figure out if people are catastrophically impaired, there's not going to be any money to spend. Their $50,000 in med rehab, their $36,000 in attendant care is going to be spoken for. And you're going to have to start prioritizing. On the cases where right now they're clearly catastrophic and we all anticipate they're going to be catastrophic, we just can't guarantee it. And it also causes attention, because now with these Glasgow outcome scale on an extended basis that get reevaluated, you'd kind of be better off if you didn't improve and you qualified as catastrophic, and then you had access to all of the benefits so that your life in the long run can be better, rather than spending your money right away, getting back to work in some capacity, and then having an insurer examiner say, no, you don't qualify, and then being out of benefits, at which point you deteriorate and you try again and you end up in a battle with the insurance company. So when will any changes take place? The Parliament's back in session. The media has now picked up again on this 15% rate reduction. They're on the clock to make the rate reduction, 8%, 15% over 2 years. So if I had to guess again, and this time I hope I'm wrong again, that I expect an announcement within weeks or months about a revisitation. The debate will start over again. The debate left the table for a good year. Now it's going to be back on the table. In my view, changes are most likely imminent, but I hope not, especially when it comes to the elimination of the GCS test. If there are any changes, it would only impact new accidents, accidents that happen following the date any change is implemented. So cases that are currently at the hospitals, and they will not be affected by any new definition of catastrophic impairment. And rest assured that advocates, including Thomson Rogers, will make sure that we work with any changes that are announced. So when we're forced to deal with it, we will come up with solutions that help patients get around these requirements, that put more pressure on the lawsuits that often take place where some of these benefits may be available to cover those gap periods. So what can we do to prevent it? We can get ready. We can prepare to advocate in response. We can coordinate and organize a response, and many of you in the room have already done just that. And when the draft changes are announced, we need to make sure that we work on refining it, to make sure that it addresses, and once it's announced, there's not going to be a lot of room to negotiate, but there will be points where we can help make minor changes that will go a long way to helping people, especially dealing with these gap periods and in the interim periods. So, as we see what happens, you're welcome to monitor thomsonrogers.com. We'll keep updates, information there about any changes, about any announcement, about what you can do to help. Thank you very much.